Yes.
Yes, Your Honor, in this case, we have filed the list of witness for the different witness, and then my colleague has already filed that. Then, since her mother had passed away recently, so she has not joined in the chamber. And then the witness has come, but then she have been instructed me that she will drop this witness. It's Nicholas or something.
Nicholas de Carrion.
Yes.
He has come today.
Where is he?
Nicholas.
You don't want to examine him?
No, she don't want. And moreover, the file is not with me, and yet I have to collect it from her house. So, but I have called her, then she instructed me to submit on her behalf that she wants to withdraw this witness. Drop.
File one application.
Yes, definitely.
Accused persons are present.
Yeah,
Tino situ, bare timo. Pura suyai.
Pura.
Lamprang situ.
Lamprang.
Elip biam.
Lumpur dia ke kong chua buat.
Jadi tiwan. Bare timo.
3 of them they are senior.
Okay.
They are absent in the strand on the reason that they have called my colleague, but then she did not receive that.
This defense counsel is in bereavement. DW Nicholas Takhar is present. Learned counsel Sri RB Hing submits that he has instruction to drop the accused, to drop the witness DW Nicholas Takhar, DW4. Defense counsel shall file appropriate application to that effect.
Yes.
Any more DWs you'll bring?
Your Honor, should I inform before this honorable court at the time when I submit my withdrawal petition? Because I have to talk to my colleague.
Right.
Yes.
Defense counsel shall take steps, if any, for DWs. Yes. Yes.
Good, yeah.
Break the lungs.
This case, the direct counsel is appearing via VC, you know. Won't join me. And I was informed that he's withdrawing from this matter, you know. He had filed one application.
Accused Break Talang is
Break
here.
Talang. I'll just brief him, you know. Pagmau niu lidar yang ti tujuh wan nasalong. O ang him de wani kampi tahap tu lidar de wima.
Where is this lawyer appearing?
Stay on a PK Shati, but it's not visible.
Accused Break Talang present. Accused Break Talang present. Defense counsel has filed petition number 11/26 dated 23/2/2026. Inter-alia praying for withdrawing his power.
Yes, appeared.
The defense counsel appeared through BC from Shillong.
Yes, please, Your Honor.
Yes. Yes, yes.
Yes, please, Your Honor.
Yes, yes, yes.
Yeah. I'm appearing for Great Talang, cell number 2. Your Honor, in this case, I would like to withdraw myself as defense counsel in this instant case.
Okay. Okay. The accused who is present before this court. The accused who is present before this court has been informed that his counsel has withdrawn his power. No notice is called for. The accused informed that he would appoint a fresh defense counsel. Fix your appearance of the defense counsel. Yes.
Witness present to receive. It's appearing from Seva from Shillong.
Yes.
It's fixed for argument.
After evidence?
Yes, yes.
We already have started this.
No notice of proclamation issued against the accused. Report is awaited.
It's what we have to use. It's what summation of accusation.
Not today.
Okay. This will step down.
This is the case he burned his house.
Yes, sir.
He fixed for. Yes.
Yeah.
Officer, you can join now.
Good afternoon, sir.
Good afternoon.
2 for the alleged murder of Lajai Kandai. The FIR has been lodged on 13 February 2007 by the complainant PW 2 Limos Sensai. Finally, read out the FIR. Opinion Casino. Subject, how officer in charge, police outpost at Sama. Subject to Jisha Panyap, Kulajai Kandat, Alat Mongor, Khalai Trek, Navar, Achani. The Jingadai subject, Kadorane, Ni Kumushnam Lat Mongor, Ni Tip Mat Kurum Spoon Jepi, the Jingadai, Mate Kam Chapanyap, Kulajai Kandat, Rin Kirtan, Ha Ulas Mongor, Lat Mongor, Khalai Trek, Navar, Achanyo, for Pravajim and Step Surop. The Jingadai, Kampanyap, Ni Nakaliang Jonkashnong. Lat Mongor Nimdon Jingtibesh Pangakam, Kajia Hagini Gibril, Kakam Kajia, Gini Gibril, Hadu, one day poi, Porch the company of Puntang, Ipin Tipshapi, or Pinsco Harman, Shim Yakajink Kile, but Ban let Yakabaran come. The PW2 is a village representative. We have examined 10 witnesses. But the IO we have not examined, as he has expired.
Yes. When did IO die?
Now I don't have the record, but court has already taken note of this, not mistaken, it's part of the record, the death certificate.
Yes.
We have examined this PW1. I may be. Shall read on. I received someone from the court. I know the accused person who is from the same village. I also know the deceased Lajai Kandai, who is also from the same village. I do not remember the date of the incident, but occurred in the year 2007. On the day of the incident, I was at home. The incident occurred at about 8 a.m. in the morning. At that relevant time, I was busy with household chores and cooking vegetables. The deceased, late Lajai Kandai, was passing by my house and sat down in the compound of my house. Suddenly, I heard the accused telling the deceased that he is tired of the deceased person, calling him again and again. On hearing the noise of the accused person, I came out of the house and saw the deceased was lying dead with cut injuries on his neck. Thereafter, I became unconscious. I did not inquire about the incident from the accused person. The accused person is present in the court dock today. In the cross, though he is a known person to PW1, the accused, so belongs to the same village. In the cross, I know the accused person and we are in talking terms. It is a fact that the voice that I heard is of the accused person. She could recognize the voice. We don't have any direct ocular witnesses. However, this case is circumstantial, as there is also an extrajudicial confession and also a confessional statement made before the magistrate under 164. And I'll read the extrajudicial confession which was made by the accused person to one witness. PW8, Mrs. Kemenlang Pawa. He is also a Caesar witness, you know.
Yes.
Yes, sir. PW8, you know. He is the person with whom the accused had made a confessional extrajudicial, you know, and also he's a Caesar witness when the weapon used for commission of the crime, you know, was seized. He was present, you know. I shall read, you know. I know of the case as I was the representative of the Darbarshnong Lat Mangor. I cannot remember the date, the month, and the year of the incident. On the day of the incident, at around 9 a.m., while I was at home, the accused person, Vitalis Sumo, came and confessed before me that he had committed the murder on the victim, Sri Lajai Kandai. The accused also told me the PO is at Lat Mangor itself, near the house of the deceased victim. Thereafter, I, along with the secretary, headman, and some other villagers, followed the accused, who went to Satsama police outpost to inform about the incident. When we reached the outpost, the accused confessed before the police about the commission of the crime, and thereafter, the police came along with the accused to the PO. I also saw the dead body of the deceased with cut injury behind his neck. Thereafter, the accused led the police for the recovery of the Khasi Dao at a distance about half a kilometer from the PO. I also accompanied the police and the accused for recovery of the Khasidaw. The Khasidaw was taken out by the accused from the bushes and handed over to the police. Exhibit 2 is the Caesar list under MR so and so, and Exhibit 2 is my signature. But how I will not be able to identify this as now the incident took place a long time ago. I know the accused person with less Suma present in court dock today is as he is my co-villager.
Yes.
Yes, sir. The other witness, you know, PW4, Darambai. He also stated the same as PW1, you know, if I may read. I cannot remember the date of the incident, but the incident occurred in the month of February 2007 at around 8 to 8:30 a.m. On the day of the incident, I was at home. While I was sitting at home, I heard the accused person, Vitalis Sungo, shouting his own name, and by the time I reached the PO, the victim, Lajai Kandai, has already died. Thereafter, I went back to my house. So this person also heard the name of the accused Vitalis Sungo, you know. Circumstances show the presence of the accused in the PO, you know. PW1 it is established through PW1, PW3, and PW8.
Yes.
Yes, Your Honor, after the arrival of the police at the PO, inquest was held, and one of the witnesses we have examined is PW6. It's Maria Pasi, I cannot remember the date so and so. The incident took place in the year 2007. On the day of the incident, as I was passing by to fetch water from Dong Mogondor, there was nobody present at the PO. When I returned back, I saw that the people were gathered at the PO and also police were present. I asked some co-villager as to what had happened, but nobody answered. Thereafter, I left to drop the water and I returned back to the PO. On reaching there, I saw the dead body of the Shri Lajai Kandai. I noticed that there was a cut wound in the backside of the neck of the deceased victim, and he was lying with his face towards the ground. At the PO, I was made to sign one paper. On being shown to me the inquest report, I state I have put my signature on it. Exhibit 3 is the inquest report.
Yes.
Yes, Your Honor. Your Honor, as the weapon seized was led by the accused himself, which is a Khasidao, used for the commission of the offense, Your Honor. Now, the PW9, who is a doctor, he has deposed on behalf of late Dr. P. Sankon, who has conducted the post-mortem examination. If you want, I will come to the opinion arrived at after the conduction of the post-mortem by the Dr. P. Sankon, was that the opinion was that the death was due to shock and hemorrhage resulting from injury to the vessels of the neck. The weapon used was a very heavy, sharp weapon. So a dao is a heavy, sharp weapon. Yes, Your Honor, though extrajudicial confession is a weak piece of evidence, but however, Your Honor, to make the evidence stronger before this honorable court, the accused himself has uh, made a confessional before the magistrate, erstwhile magistrate who has expired, J.D. Suchiang. However, we have exhibited the document to PW10. This is exhibited as exhibit 5.
Yes.
Yes, Your Honor. Your Honor, my learned friend here, Your Honor, has relied on one decision of the Honorable Apex Court, in the Saha Devan and another versus State of Tamil Nadu. I must have Saha Devan and another. Your Honor, there is principle which the Honorable Court has relied upon. This is para 16, the principles. These are the principles which this Honorable Apex Court has laid down. If I may read, upon a proper analysis of the above referred judgment, it will be appropriate to state the principles which would make an extrajudicial confession an admissible piece of evidence capable of forming the basis of conviction of the accused. These precepts would guide the judicial mind while dealing with the veracity of cases where the prosecution heavily relies upon an extrajudicial confession alleged to have been made by the accused. The extrajudicial confession is a weak evidence by itself. It has to be examined by the court with greater care and caution. It should be made voluntarily and should be truthful. So here the accused, has come to PW8. He has come voluntarily. Nobody has coerced him. Come and confess before him, It should inspire confidence. Why inspire confidence in this case is that the accused himself has led to the recovery of the dowry, the PO, he has led to the PO, and the confession made before the magistrate. An extrajudicial confession attains greater credibility and evidentiary value if it is supported by chain of cogent circumstances. So, circumstances from the evidence, it reveals that the presence of the accused at the PO, the recovery of the dowry, these are the supporting evidence to which, and the 164 confessional made by the accused himself. So these are the evidence gathered by the prosecution to build a chain of circumstances, for showing the presence of the accused, recovery of the weapon used. 164 statement also has been made, So the extrajudicial confession made by the accused before PW8, has to be taken on board to arrive at a conclusion that the accused has committed the crime, murder of the deceased late Lajai Kandai, That's my submission. I reserve the right to reply also.
What is this judgment 2024?
That's for section 27,
Recovery.
leading to the discovery. Para 66.
Evidence Act. Recovery has been established through witnesses here. They were present.
PW4.
Yes. Not only PW 8 and PW 4. Both of them were present. And they have seen that the accused himself has led the recovery. It's not that the police has placed or fixed anything as such. And in the cross also, there is nowhere that they have discredited that fact.
I'd like to reply.
I'll just further submit. And I'll read section 27, Indian Evidence Act. How much of information received from accused may be proved, provided when an A fact is deposed as to discover in consequence of information received from accused person of any offence in the custody of a police officer, so much of such information when it amounts to confession or not, as relates distinctly to the fact thereby discovered may be proved. Here the recovery was led by the accused himself. No other person was involved for placing or fixing any weapon. It's the accused who has led the police along with the witnesses who has been able to prove for his honorable court, and the defense has not been able to discredit them. This is the fact. It remains intact through the evidence of the witnesses.
But you read paragraph 16 of this judgment relied by them.
Yes.
If any recovery is made pursuant to the accused leading to the recovery, then first a recovery statement has to be recorded
Yes.
in presence of independent witnesses, where the accused will say that I want to make
Confession. Recovery
yes,
statement.
I want to lead for recovery. So that statement has to be recorded. Thereafter, the officer who is recovering the materials, he will proceed to the place on being led by the accused, and then there has to be an independent witnesses before whom a seizure has to be made. But in this case, where is that recovery statement?
Statement is not there.
That's what para 16 says.
66.
Oh, sorry, 66.
That's all. I reserve my right to reply if any.
Yes.
First, I'll go to PW1. PW1 stated, I'll just take a portion. The deceased Lajai Kandai was passing by my house, sat down in the compound of my house. Suddenly, I heard the accused person telling the deceased that he is tired of the deceased person calling him again and again. This is simple. On hearing the noise of the accused person, I came out of the house and saw the deceased was lying dead with cut injury on his neck. Therefore, I become unconscious. That stated she heard the accused came and said that he was tired of the deceased person. This was happened in the compound. She stated that she saw the deceased passing by and sat in the compound and hearing the noise of the accused. Thereafter, she came out. She saw the deceased was lying dead. She never stated whether she saw the accused or not. Even if he committed a crime, she must have saw him running away or so. She never stated that. She become unconscious. She stated that. Whether the accused was there in person, she never stated she saw. Even running also, she never stated that. For PW1. Now I'll come to PW8. PW8 is where the accused made a confession as well as he is the seizure witness. There's two seizure witnesses in this said case, PW5 and PW8. PW8 is the person who stated that the recovery was led by the accused person. However, PW5, if I may read, he was silent about that. PW5. Stated that on a day of incident, I was passing by through Lat Mungor village. I saw the dead body of Lajak and Kantai lying on the roadside. When the police arrived, I accompanied the police to seize the weapon for committing the crime. I saw the police seize the weapon, which is a Kasidao. Exhibit 2 is the seizure list. MR so and so. Exhibit 2 by 1 is his signature. Stated, I will not be able to identify the seizure material now. This incident happened a long time ago in Cross. Exhibit 2 was not read over to me before I put my signature. The Kasidao was seized from the place located about 100 meters from where the dead body was lying. I remember there's another witness exhibit 2, but I cannot remember his name. He was silent. that the seized dog was seized on being led by the accused person, Your Honor. Moreover, Your Honor, PW8 is also the where the accused allegedly by the was stated that the accused had made a confession before him, Your Honor. The PW8 is a representative of the Barcelona, you know. Stated the accused came and confessed that he had killed Lajak and died. And the PO is in Latmangor also, you know. So he stated in cross-examination while accused made a confession, there's also other 4 persons present along with him, which was never examined before this court. Nevertheless, you know, it doesn't matter if the number of witnesses to be examined or the quality is it's matter. What I'm trying to say is, you know, this person who is a representative of the village he stated that the accused came and confessed before him. Thereafter, he went to Sajma Outpost to report the matter with PW2, who is also the representative of the village. Then PW2 stated that he filed the FIR based on the information received that from a villager, which was never examined, that the accused assaulted Lajak and Taigana. However, this PW8, despite going to Sajma Outpost with PW2, he was silent that accused person has came before his house and confessed before him. Moreover, he stated that the accused also confessed before the police. However, to his complainant who is present, he was silent about that. You know. And I'll come to confessional statement before magistrate. If I may, what the accused was confessing. This is the confession made by the accused. He stated, I, Sri Vetila Sumo, who is the accused person, do hereby confess that I have committed the crime for self-defense. That is the content of 164 made by the accused. Now, this content did not really, the accused here did not specifically state what crime. And moreover, even if we take this, he stated there's justification that he did it for self-defense. Moreover, we don't know. He just stated, I committed the crime. What crime? We don't know. For self-defense. That is his statement recorded by the magistrate. Moreover, it's a matter of a record. So, the accused was arrested on 14, forwarded on 15 to the court. And the 164 of the accused also recorded on 15, That's a matter of record. To support my argument, I've listed 3 judgments, that is Babu Sahib, that is for the section 27, which we just read, that the Panchanama is needed, the discovery statement has to be recorded, section for extrajudicial, I've placed one more judgment.
What is your explanation?
My explanation is that for the whole thing, that on that day.
Explanation to the confession, extrajudicial confession you made.
Stated he never confessed before the PWA, and for 164 stated also he never confessed before magistrate. I've relied 3 judgments, for leading to discovery, extrajudicial, and 164 statement. I've placed here. Yes, those judgments are those which are yes, for this extrajudicial is 14, which state that it's a weak piece of evidence. Extrajudicial confession is a weak piece of evidence. It needs corroboration, from all angles. If we go in this case, first Caesar's there's no corroboration because one witness stated is led by the accused. One witness was silent about that. Moreover, there's no discovery statement. And for moreover, this person whom this accused came to confess, upon going to the police station, he was silent about that, He's silent to the headman also, to the PW2 who is representative, who filed the FIR. As per the statement of PW2, he stated that he filed the FIR based on the information received from villager that there was an assault between the accused and Lajak and Taigana, who is the deceased. This is my argument.
Extrajudicial confession statement is a weak piece of evidence.
As stated by the
So, but it does not mean that we should discard it.
yes. You need corroboration. That's what it said.
Yes. That's all?
Yes.
Yes. Anything you want to reply?
Mm.
We'll not keep it for judgment because we'll dictate in the court. We have too many judgments pending. Keep it for the hearing, but then such hearing is concluded. Next day, these are the judgments you.
Yes. Please, three judgment.
On the same judgment which my learned friend has relied, I also has that para 16. No?
Ayon on session ke 16 of 2022. It was just his now being me kanai.
Item number 6. No? 213.
Please take it.